Let's talk about the relationships between debtor and creditors. And this usually happens when the relationship that they have kind of falls apart, and there's a dispute that arises over whether or not the amount is owed, and whether or not the debtor can simply pay or cannot pay or refuses to pay. So the creditor has a number of remedies that are available when the debtor defaults. And the types of laws that are available to a creditor include liens, garnishment, suretyships or guarantees, and mortgage agreements. We're going to talk about mortgage agreements the next topic. I am going to talk about liens here in the book. Liens and mortgages are discussed together in that chapter, but I think the liens fit much better right here, and I will kind of recap them when we talk about mortgages, but I want to talk about liens right now. So what's a lien? Creditors claim on real or personal property to secure payment of a debt or performance of an obligation, and there are a number of different types of liens. We have a mechanics lien, artisan's lien, tax liens, innkeeper liens, and judicial liens. What's important about liens? What is important about liens is that they generally take priority. So they usually jump the food chain, take priority over any other claims against the same property. In most instances, such as in our mechanics lien and our artisan's liens, they're going to take priority over even perfected claims. So very important. Let's talk about each one. Mechanics liens. We also call them material men's liens. You've probably heard that term before. It is actually statutory created, which means it's state by state. It's a legislator made law. You'll find it in statutes, and it's a lien on real property of another, created to ensure priority of payment for work performed. So it's attached to real property. We'll discuss that when we talk about mortgages. And it ensures payment for work that was done. So for example, a contractor does home improvements to real property, does some work on a house, maybe builds the house, maybe remodels the bathroom, and they don't get paid. They file a lien, and they file the lien in the county office where the property is. So what they have to do is they go down to the county office. There's actually a document, a piece of paper that they could fill out. There's a form of a checklist. There's certain requirements that have to be included in that document. We're not going to go into that here. You just have to know, one, that there's a specific document that they will have to file and put on notice to everybody that this lien exists to this property. That's the filing of it in the county office. But they also have to serve a copy on the property owner and give them notice. And just by way of background, how it works in New York State, you can go and you can file your mechanics lien, but it is only good for 1 year. After that, there is you can renew it for another year upon within 30 days of its expiration. But after that, it's gone. And what you need to do to enforce your lien is you have to start a foreclosure proceeding. And we'll talk more about that when we talk about mortgages. So certainly there are some issues that can arise if you have a mortgage on that property as well, because this mechanics lien could take priority. And again, we'll discuss the logistics of this lien and how it works with a mortgage when we talk about mortgages. Then we have this artisan's lien, and this is created by common law, which means it can differ from state to state. And it occurs when one repairs or improves personal property for another and retains possession of that personal property. So it's a possessory lien because they have to retain the property as security for payment for the services performed. So the key is they have to have it that's when the lien exists, because they have possession of the property. And once they voluntarily surrender that lien, the vehicle, or I say vehicle because I'm going to use that in my next example, but once they voluntarily release the property to the owner and they haven't been paid, the lien is gone. So you have to have possession of it. So the best example of this is a mechanic. When a mechanic repairs a car, upon completion of the repairs, you got to pay the mechanic or they're not going to release your car. That ensures them payment. Or another example is Selena leaves her diamond ring with a jeweler to have her initials engraved on the band. She's to pay when she picks up. The jeweler keeps the ring until she pays for the services. What happens should they fail to pay and these folks are hanging on to the property? They could technically sell it. They could sell the property. But what if, let's say in the case of the ring, what if the ring is worth $3,000 and the engraving's only $100? The jeweler only has a lien on the property for the amount of the bill. So if the jeweler, they would, before they get to sell it, they actually have to get a court order. So they would have to start a legal action. It's usually in the form of a foreclosure because they're asking to gain possession of something so that they can sell it, i.e. they need to get a proper title. Otherwise, probably can't. So they have to go to court to get that permission. But once all of that's said and done, they sell the ring for $3,000, they'll get their court fees back. Then they'll get their $100 bill payment in the case of the ring. And then the surplus has to go to Selena or the debtor in that instance. Then we have tax liens, innkeeper liens. Tax lien is obvious. The government is for them to secure their taxes. And I will tell you, a federal tax lien is going to trump all. They write the rules. It's the federal government. So federal tax lien is going to be a very high priority chain member. Innkeeper's lien is kind of obsolete at this point, but surprisingly enough, they still test on this issue on the CPA, so I just wanted to throw it in here. Basically, a hotel can retain a guest's baggage for payment. Obviously, I don't know if you've spent any time getting a hotel room, but when you go, you have to leave your credit card number at this point. So they have that security in the form of your credit card, even though you may leave and want to pay in cash. As long as you are there, they want a secured credit card number, and so you do pay in cash. So that's not really happening anymore. Then we have what the book calls judicial liens. I've never used the term judicial lien before in court. So I call these things that we're going to talk about here, these writs and garnishment, I'm going to call them collection tools. What creditors have, they have these tools when they go to court, what they can do. So a creditor sues somebody in court for money. Okay, the debt's past due, and they go to court and they sue for the amount of the debt. Usually when they win, what they get is a judgment. I call it a money judgment, but they'll get a judgment that says the debtor owes X amount of dollars and it has to be paid within 30 days. If after 30 days it's not paid, then the creditor can file this document as their judgment with the records, and it shows that there's a quote-unquote lien on real estate, usually if you're filing it with a county building. But they take steps to file it out there so other creditors know that this judgment exists in some fashion. These kind of judgments have a very low priority. They're way down on the priority list of getting paid off, so they rarely ever get paid off when they're in this form. There are a couple procedures in between that can happen before they get there. Is they can start their court action, and if they are aware of the fact that the debtor has property of value, personal property of value, we're not talking about real estate here, we're talking about personal property, and this does not mean the property has to be some sort of collateral that the debtor already agreed to. It could be any sort of property. So let's say I have a tractor on my farm that is not, there's nothing attached to it, but it may be worth $20,000, and the creditor wants to get paid their money that they owe me. They can ask the court for something called a writ of attachment, and this is before the case is over, so before the judge issues a judgment. They can ask for a writ of attachment. They say, Rebecca owes us $20,000. We understand that she has a tractor that could be valued at about $20,000. Judge, we're asking you for an order for it to be seized while this case is pending, meaning I can't do anything with it. I can't sell it. It gets held until the court makes a decision. If it appears as though the creditor is going to win, the court can also order it sold. But at this juncture, the court can order it seized or held, and I can't get rid of it in any fashion. After the judgment is entered, and we know that the money judgment's $20,000, the creditor can then ask for a writ of execution, which means it's seizing that property or that tractor after the fact, and the sheriff will go and get it. And that's how the writ of execution will happen. The sheriff will be directed to go get it with the order, and then ultimately the sheriff would be responsible for selling it at some sort of private or public auction. So it could be any property whatsoever. Then we have this concept of garnishment. This allows creditors to seize money allows creditors to seize money that's owed to a debtor by a third party, or that third party is holding on to that money on the debtor's behalf. And the two most common examples of this is the debtor's employer, because they get a paycheck every week from that employer. And the other concept is a bank. A debtor might have a bank with some money in it, or where their paycheck goes. And the rules regarding it vary from state to state on how the garnishment is used. Most often, it's after they obtain a judgment from a court that says $20,000 is owed. They have a judgment. They have to try and collect their money. So what they can ask the judge to do is give them a order of garnishment. And they have to be specific. Judge, we understand that the debtor has a bank account with NBT bank account, and there's money held in there. It doesn't matter how much money is held in there, just that there's a bank account that exists with money on it. We're asking you for an order of garnishment that we can turn over to the bank. And if the judge agrees, they will give them their garnishment order, and the creditor has it served on the bank, usually with a sheriff, but somebody can serve it on the bank. And the bank has to seize the account, which means you can't get any money in or out of the account. It's seized and it's held. And then there'd be some sort of process that it be turned over to the creditor once the judgment is established as accurate and so forth, and how much would, because if there's only $5,000 in it, they might be able to take the entire $5,000. If there's $30,000 in it, clearly if it's a $20,000 debt, they can't take the $30,000. So once the debtor is allowed to respond to the whether that's a valid debt or not, then the process will take place of getting the money from the bank. Now, the employer one is the one that is used more often because it's easier to get than the bank. There's a few extra steps to get money out of a bank account, but we're talking just about the garnishment. Now, if a debtor is employed, the garnishment order, just need one order, take it to the court. Debtor works at, pick your employment location, GMC, whatever. Judge, and we would like to have his wages garnished. So the judge gives an order, they serve it on the employer, and the employer is required to take out a certain amount of money to make payments against the order that's owed to the creditor. Now, that also varies the limits. There's laws that limit the amount that can be taken out from the wages. You just can't take full-fledged wages because then nobody can live and eat and have rent. So the laws from state to state differ as to an amount, but there's usually a limited amount, and it's some sort of percentage of what the person makes. So it's not a full-fledged, I'm going to take your paycheck every week until you pay me off. But it is something that can be done. They only need one order, but one order per place. If you want to order for a bank, let's say maybe the debtor's employed at 2 places. There's 2 places, you need an order for each place, but you don't need one for each paycheck. It's automatic once the order is established and the employer is served with the garnishment papers. Then we have suretyships and guarantee agreements. And under both concepts, what this means is that a third party is promising to pay the debt owed by a debtor if the debtor doesn't pay. So we have kind of two situations, but the concept is the same. There's a third party that's promising to pay that debt. And these rules apply in both situations, and then I'll tell you the difference between a suretyship and a guarantee. So we have a third party that promises to pay the debt that's owned by the debtor. The third party's credit is what's acting as the security. And the whole point of this is, the whole purpose or point is to protect the creditor by providing the creditor with added security for the obligations and to reduce that creditor's risk. So, for example, in order for D to obtain a loan from C, S, who has good credit, promises C that he, S, will pay the debt if D doesn't. And what is that? Does that jump into your head as like you recognize? Is that like a cosigner, right? Cosigner agreement. And that's usually what that is also referred to as cosigner. So these are our parties. Parties have special names. We have our creditor, who is our obligee to the principal debtor, or of the principal debtor. Then we have the principal debtor, and that's the person who has the liability for the debt owed. And then we have our surety or guarantor, and they promise to perform or pay the debt of the personal debtor. Nice and simple and sweet. So suretyship. Let's talk about the difference between these two. So we have a suretyship. It's a contract in which a third party to a debtor-creditor relationship, the surety, promises to be primarily responsible for the debtor's obligation. So this is an expressed contract between the creditor and the surety. So they are primarily liable. What do I mean by that? What do I mean by primarily liable? As soon as the debt is due, the creditor calls up debtor, says, hey, where's my money? And the debtor says, don't have it. As soon as it comes due, they can go calling on the surety and demand payment to the surety. They don't have to exhaust any remedies against the principal debtor. They don't have to sue the debtor or anything of that nature. So, for example, if Robert wants to borrow funds from the bank to buy a used car, and because Robert is still in college, the bank will not lend him the funds unless his father, Joe, who has dealt with the bank before, will co-sign on the note. So by adding his signature to the note, Joe becomes primarily liable for the payment of the debt. So technically he's jointly responsible for the debt. And then our guarantee agreement makes an agreement to a third party to satisfy the debt of another only if and when the debtor fails to pay the debt and the creditor has made attempts to collect. We call this secondary liable. They have to exhaust secondary liability. So they'll be secondary liable, meaning that the creditor has to notify the guarantee of the debt and that the debtor hasn't paid, the steps that they've taken to collect from the debtor, and they have to exhaust all of their legal remedies first, which means they have to sue the debtor, get maybe some judgment paperwork, but nonetheless they have to go through the process before the individual guaranteeing the loan will have to be responsible. So with these agreements, our general contract principles apply. The two main ones, consideration, an agreement must be in writing. We have to have consideration in order for there to be a valid contract. So if debtor asks a relative to act as a surety to induce creditor to make the debtor a loan, the consideration is debtor's consideration gives to the credit also acts as the relative's consideration. So there's technically, the third party isn't putting up consideration. It's the debtor's consideration that is also going to be the consideration of the surety or the guarantor. So with regards to it being in writing, statute of frauds, remember, this kind of agreement to answer the debt of another, statute of frauds applies. So this kind of agreement, third party agreement involving these three parties and a co-signer, must be in writing. So C, loan $200,000 to D. The terms provided that the loan is callable by C with 1 month notice to D. C gave the agreed notice and exercised her right to call the loan. D couldn't pay the loan, so D requested a 60-day extension. C agreed to the extension when S agreed to be a surety. Is there consideration in this case? Yes, there's new consideration. What's the new consideration for the new surety agreement? Because initially there wasn't a surety. It's the extra 60 days that D gets. So it's usually the debtor who's getting the benefit, not necessarily the surety, but that's what's considered the consideration. So S agrees to pay debtor's debt to debtor's creditor in the event of a default. The main motive of S is to keep D in business to assure a steady supply of an essential component. Does this agreement need to be in writing? As I said, all of these agreements, the agreement to answer the debt of another, falls within the statute of frauds, so it has to be in writing. But remember that exception, the main purpose rule, the main purpose doctrine. If the promise is for the benefit of the surety, then it does not need to be in writing. So here, S would be getting a benefit because he's trying to assure a steady supply of the essential component. So this one would not have to be in writing. And what about this one? Father says, ship goods to me, to my son. That should be my. Ship goods to my son, and I will pay for them. Is this a surety ship? No, it's not. This is not one of those types of contracts. This is just a straightforward, they're not promising the debt of another. What's happening here is just an original promise to pay for goods that creditor delivers to the son. So this is not a surety ship. So creditor's rights and remedies, I kind of broke them down with regards to the who the opponent would be. So against the principal debtor, the creditor's rights and remedies, they have the right to receive payment and performance specified in the contract. The creditor may proceed immediately against debtor upon default. Generally, if defaulted debtor has more than one outstanding account with the creditor and makes a partial payment, the debtor can choose which account it goes to, but with no instruction, the creditor gets to choose which account they'll apply the payment to. And then against the surety, what kind of rights and remedies the creditor has against the surety? They may proceed immediately against the surety upon debtor's default. They do not need to proceed against the debtor first, and they do not have to provide notice to the surety with regards to proceeding against surety or any notice regarding the default of the debtor, unless that's part of their agreement, unless they've agreed otherwise. Now, against our guarantor, the creditor must give notice of the principal debtor's default and their attempts at collecting, and they must exhaust all their legal remedies against the debtor before they can go after that individual. And their rights against collateral, well, that's an easy one. That's the one they usually go to first. And upon the debtor's default, they can resort to repossession. And then, like I said earlier, if they need to collect more, they can bring an action for the balance that's due after they sell the collateral. And our surety folks have rights as well. They have rights and remedies in all of this. They're just not hanging out there saying, oh, we'll be here to pay the debt if we have to. So both of them have the same, the surety and the guarantor have the same rights and remedies, so I'm just going to lump them all together here. So what happens when the creditor comes a-calling? Well, they have, the creditor gets, comes a-calling and they pay. Okay, that's where we are right here, right now. The rights that they have where the debtor has not paid the debt, and these folks have now paid the debt, and now we're seeking to get that back from the debtor. That's what these types of options the surety has. So the surety has already paid the creditor, and now they want to seek collection against the debtor. And they have three ways. The first way, subrogation. This is where they step. Subrogation means it's the right of a person to stand in the place of or be substituted for another. And they have all of the same legal rights as that person. So basically the surety is stepping in the place of the creditor, and they will be able to exercise all the rights that we just talked about that the creditor has against the debtor. So they can, they have the right to sue, they have the right to any judgments, they would have the right to any collateral, so they can proceed just as a creditor would if the surety had paid off the creditor. They're entitled to reimbursement, so they have the legal right to be restored, repaid, or indemnified for any costs, expenses, or losses incurred or expended on behalf. And then they have this right of contribution, and this happens when there's more than one surety involved that obligated the debt of the debtor, and one of them pays more than the other. The one who pays more than the other can seek the excess from the other surety, so they can kind of go after each other for the amounts, contribution. So C, the creditor required D, the debtor, to put up personal property as collateral on a loan, and to also use S as a surety on the same loan. So upon debtor's default, C chooses to resort to S for payment. And what are S's options? Well, S would have to pay the creditor because they are the surety. So now S pays the creditor, but they're also entitled to that personal property that was up for security. So then they can sell that, or they can keep that, but they stand in the shoes as the creditor in this instance, so this would be a form of subrogation. And then they could seek further payment or any default after selling the property. They can go for any deficiency judgment against the debtor. But in this example, this was S stepping in the shoes of the creditor and proceed by a subrogation. Now let's talk about their defenses. So the creditor is coming after the surety for payment. Do they have any defenses, or do they just have to suck it up and pay? They do have some defenses if they exist. If any defenses exist that the principal debtor could have asserted, then they step in those shoes and they have the ability to use those as defenses in their case. And these are all of the same defenses in ordinary contract law that we've talked about. So if the principal debtor can say that the creditor breached the contract, or that it's an illegal contract, or it's impossible, or it was obtained by fraud, duress, mistake, misrepresentation, it violates the statute of frauds. If the principal debtor could make those arguments against the creditor, so can the surety. There is an exception to that, and those are the defenses that are personal in nature, such as the debtor's capacity. if the debtor is incompetent at the time of entering the contract, or the debtor files for bankruptcy. Those are two defenses that the surety would not be able to argue. They wouldn't be able to say, sorry, creditor, we can't pay you because the debtor is in bankruptcy. That's what the creditor is trying to avoid, is if the debtor went into bankruptcy, they have this security called the surety. So they cannot argue those. However, they could use those in their own defenses. They could say things of like, we lack capacity to enter the contract, or maybe they file for bankruptcy. So they can use those on their own defense. They can't say because of the debtor's capacity or the debtor's bankruptcy. Okay? But they have a right to assert all of those other defenses, that it was obtained, the debtor's signature was obtained by fraud or duress. They can also say that their assurance was obtained by fraud or duress. So they have a number of defenses that they can assert. And modification, if the creditor and the debtor modify their original agreement and they don't tell the surety, then the surety, there is no more suretyship. It's gone. So material modifications to the agreement between the debtor and the creditor will discharge the surety if consent is not obtained by the surety. Unless, of course, there's always an exception, unless the modification benefits the surety. So some examples that would be considered material modifications: an extension of time on the principal debtor's obligation, a change in the amount, place, and manner of the obligation, the duties of the principal debtor, if there's a substitution of the debtor or another debtor being added. Those things are all material modifications. If you don't have the consent of the surety is not going to be responsible. They'll be discharged from their obligations. Now, an example of a benefit that where they would not, their consent wouldn't be required. Let's say the creditor lowers the interest rate. Well, it lowers the risk to the surety. So that would be a benefit. So they don't need notice of that. So that finishes up our last topic in this area. The next topic's going to be mortgages, and then we'll have the next exam. Work through those examples. I'll put up the answers to those so you can work through any of these. Email me if you have any questions.